the notice of hearing and right to object to the appointment of a public administrator who would then be serving as a personal representative. Hi, I'm Darren Findling of the Probate Pro, and we're going to cover a particular SCAO form, PC 689. SCAO stands for State Court Administrative Office. PC 689 is the form number. You can see it in the bottom left corner. In addition, where that little yellow arrow is, it references two statutes, 700.3414 and 700.3611. These are the statutes that give rise to this particular form. And this particular form has a very unique use case in that it is a particular type of notice of hearing that is used in a petition for probate in which a public administrator is being sought to be appointed as the personal representative. Now, in a typical context, the personal representative that's being sought is either nominated in the will or is a family member, and a traditional notice of hearing would be used. But when a petition is filed and there is a public administrator being sought to be appointed personal representative, then this particular notice of hearing is used because it provides with the recipient who receives this, the interested parties, the rights under the statute to object to the appointment of the personal representative. Let's work our way through the document. In the top left corner, you'll see that there is a place for the county, and in the top right corner is the case number and the judge. At the top, the address of the court, and then, of course, in the matter of is the name of the person that died. I am a public administrator is the beginning of this document, which means that this notice is being given by the public administrator to the interested parties that a petition for probate has been filed. Now, why would this happen? There are circumstances in which a probate may need to be opened by a public administrator. There could be a set of circumstances in which action needs to be taken, in which the person's body may need to be buried and nobody has come forward, or there's a tax reversion that's going on a property in which the the decedent owned and nobody has been appointed by the court. There could be other circumstances in which a public administrator is appropriately sought, and that is governed by Michigan statute. We're not going to cover those particular use cases here, other than the fact that when the petition is being filed by a public administrator seeking their appointment as personal representative, this is the required notice. It then goes on to say that they have filed a petition for probate for the estate of the individual named above, and the decedent's real property has delinquent taxes and or is a mortgage foreclosure. So imagine the government is moving forward to forfeit the individual's taxes on their real property, on their home, or there's a mortgage foreclosure that's going on, and there's notice requirements, and there may be a foreclosure that requires that the action be served upon the decedent, and that decedent has no representative. There's no personal representative in place to accept service of process of the action, whether it be a tax forfeiture or a mortgage foreclosure. So this process allows for somebody to get appointed by the court to accept service for due process purposes. It says that there's going to be a hearing. That's that bottom section. It identifies the date and time, the location, and the judge's information. And then the rest here are the advice of rights. It says you are required to be given notice under 3414 as an heir, which is a family member. You may object to the appointment. The court, you may petition the court for a hearing on any matter, including the appointment of the personal representative, the petition to remove the personal representative during the estate administration, and then you can identify the basis for those removals. So it's really important that this particular notice be given, because when somebody receives a petition for probate in the mail or is served a petition for probate, this advises them of their right to actually object to the petition. And objecting can include, hey, I'm named in the will, I'm nominated in the will to be appointed personal representative. I have priority over the public administrator. or maybe they're the child of the decedent, and a child of a decedent would have a higher order of priority for the appointment of a personal representative than the case of a public administrator. So this notice is given specifically to provide notice to the interested parties, the heirs, of the request of the public administrator to open the estate and seek their appointment as personal representative. And the bottom section just simply has a signature. So a very unique and particular use case, but it's designed to protect and provide notice to people that are involved in these circumstances that involve mortgage foreclosures or tax delinquencies through the tax reversion process by the county. At the Probate Pro, we are passionate about everything probate. If you have questions about this particular form or any probate-related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.